All right. Good morning, everyone. Welcome to another edition of Get Closed, Get Paid. And my name is Erin Michelle Miller, and I've got Kristen Jaiven here as well. We are Florida-based attorneys, and we offer free Zoom classes every second Tuesday of the month. And sometimes they're on legal topics, contract topics. Other times they're on marketing, other issues that need to be dealt with here in the real estate industry. Also, Kristen represents brokers and agents in dealing with issues of compensation and disputes and helping set up their business properly, and I do real estate closing. So we have a very special hot off the press topic today. We're going to talk about the new FAR Addenda that were just released in the past couple of weeks, and the FR form, the Florida Realtors form, related to the flood disclosure. Before we dive in, we're going to go to my very favorite slide, which is the attorney disclaimer slide. So we are attorneys. We are not creating an attorney-client relationship with this presentation. We're just an educational forum. And though Kristen and I serve on a number of committees, both at the Florida Bar and Florida Realtors, including the Joint Realtor Attorney Committee that revises the FAR Bar contract and addenda, the opinions that we give today are just the opinions of Kristen and Erin, not necessarily opinions of the committees on which we serve. Also, these classes are a forum for the sharing of ideas, fostering open discussion, and we are not going to participate in any discussion that would be deemed to be anti-competitive in nature. So this is our anti-antitrust statement. With all of the formalities out of the way, let's jump into our agenda today. We're going to talk about the FAR Rider F, credit related to buyer's broker compensation, FAR Rider G, seller's agreement with respect to buyer's broker compensation. I call Rider G the contingency addendum, and FAR Rider A, the condominium rider that was just recently updated last week. So make sure you're using the 2024 version of the FAR Rider A related to condos. And then we'll talk about the flood disclosure that was released by Florida Realtors to comply with the law that changed as of October 1st. So as I mentioned, we will answer questions at the end if you'd like to, once we stop recording. But if you want to go and put your questions in the chat, we might be able to answer them as we go, but we'll let you unmute yourself at the end and we can have a conversation. All right, the first form, Kristen, tell us about the genesis of the credit related to buyer broker compensation addendum.
All right, so we've got two new riders that are came out of the FAR Bar committee, of which Erin and I both are on, that deals with the compensation issues arising out of the NAR lawsuit. So we all know, I don't know how many transactions we've all done since August 17th, but we've got listing agreements and buyer broker agreements and CABBs and CASBs and comp forms and every other type of form that we've seen brokers come up with to document commission now that commission offers are no longer occurring on the MLS. This document here is a purchase contract rider. So this attaches to either the FAR Bar as is or the FAR Bar standard. And you can attach it. And what it does is you can, with your offer, and try to move any buyer compensation that the buyer has agreed to pay buyer's broker pursuant to either a comp agreement or a buyer broker agreement or a showing agreement, whatever the case may be, and ask the seller to offset some of those expenses. Hold on one second. The amount here, it's very important to remember that this money exchanges between the seller and the buyer. This is not the seller agreeing to pay the buyer's agent. And the reason for that is that brokers are not part of this contract. So the only thing, and only terms any writer of the FAR Bar contract can dictate is what really occurs between the buyer and the seller. So this is a credit from the seller to the buyer. Now, what makes this different than any other credit that you would do for closing cost or some sort of repair credit or any of the other credits that we're used to? The key here is this bold language that says seller agrees to credit buyer the sum described below for which disclosure purposes only the parties agree is related to buyer's obligation under the buyer broker agreement to pay all or a portion of buyer broker's compensation. The reason that that is there is to earmark this specific credit as credit towards compensation. The reason for that is IPC limits. So we all know that traditionally you could only credit certain amounts of money without a lender objecting to the credit. there's temporary guidance in the lending world that says if the cost was traditionally paid for buyer broker compensation was typically paid by the seller in the area you're operating, then it's not going to be subject to IPC limits. The key, though, is that it's clear that that's what this credit is for. If you're working, though, with a buyer who has a lender, be sure to show them this rider first and make sure that they're okay with how this is earmarked. Because there could be lenders that say this is not sufficient. This rider has been in the world, I think, 2 weeks now. We haven't had any feedback yet, but we need to know what lenders are saying about it. So hopefully it's sufficient and lenders work with it. But that's the purpose of this. There's language in the paragraph below. Yeah, go ahead.
Can I pause you real quick? So IPC limits are interested party contributions.
Oh, yeah,
so a buyer can only receive a certain amount or a certain percentage of the purchase price towards closing costs, towards prepaid, towards surveys, towards attorney fees, that kind of thing. So we know that each lender and loan product might have their own limit as to how much a buyer could receive from any party in the transaction, whether that came from the seller, from the listing broker, from the buyer's broker. Those are all subject to what we're calling the IPC limits, the interested party contribution limits. Now, we do have temporary guidance, as Kristen mentioned, that if the credit from the seller is for something that is customarily paid for by the seller, which in our world here in Florida, typically the broker compensation had been paid by the seller, whether it's directly from the seller or through a listing broker. So we have guidance that will say that if the credit is earmarked for buyer broker compensation or something that is customarily paid for by the seller, that will be above and beyond that IPC limit. So a buyer could potentially receive a credit towards closing costs and prepaid up to the IPC limit. Of course, you're connecting with your lender to find out what that limit is. And then also, if you have this credit related to buyer broker compensation addendum, the buyer could potentially be receiving a credit from the seller towards the payment of that buyer broker compensation. And Kristen mentioned that this will need to be attached to the contract and incorporated into the contract. So you'll note that currently our FAR sales contract, whether it's the as-is or the standard contract, does not have a particular checkbox specifically yet for FF and GGs to reference these particular riders. So make sure you check the box in other and reference addendum for rider FF or rider GG to make sure you're incorporating it. If you don't incorporate it in that checkbox, then make sure you're referencing in other terms and conditions, again, that rider FF or rider GG are incorporated into the contract. We know that attaching without incorporating or sending it all over without incorporating is not sufficient to make it a part of the sales contract. You want to make sure you're checking a box and doing something to incorporate it into the contract. Now, Kristen, when would you potentially need this addendum? Like what is the scenario when you would decide to use this as opposed to one of the other forms that might be available?
So I think this is the form that you use if you, both FF and GG, which we'll talk about GG in a minute. These are situations where the buyer has agreed to pay compensation through the buyer broker agreement. You'll note that this contract says you're not going to, that the credit is not going to exceed, what the compensation was agreed to. That comes from the settlement. The buyer's broker cannot accept more compensation than what's in their buyer broker agreement or their showing agreement or whatever the case may be. But if the buyer has agreed in the buyer broker agreement to pay a certain amount and they know they want that to be offset in their transaction by the seller in some form or fashion because they don't want to come up with that cash to pay at closing to pay their buyer's broker. In theory, and ideally with best practices, you would be able to get a compensation agreement from the listing broker or the seller prior to presenting the offer. But the FAR bar, was presented with lots of scenarios in which that might not be the case. Listing agent possibly doesn't answer the phone. Buyer is ready to make an offer. It's a Saturday at midnight. They don't know what the compensation is, but they know the buyer does not want to pay out of pocket. So the deal needs to incorporate the compensation. And that's where you're going to ask for a credit. That way, when the offer goes out to the seller for consideration, they know they're asking for that compensation to be covered. The same for if we want to flip to GG. So FF is...
And then I want to come back to FF.
Yeah, let's just talk to GG. GG is a contingency. So GG submits the offer. It doesn't say I want the compensation to be offered from the seller to the buyer. It just says I want my compensation covered, and this contract, my offer is contingent on getting that compensation worked out. This is a very, in my opinion, a very last minute, last effort document. This is for the situation where the listing agent has not cooperated at all. You don't know what the compensation is. You want to present the offer, but you need to present that offer and open up negotiation as to the comp because the buyer doesn't want to pay the comp directly. You can make this offer contingent on a compensation offer acceptable to buyer being executed within a certain number of days. As best practices, I would say to align those days the same or shorter than your inspection period. That way you're not letting this compensation issue drag on indefinitely. But in the practice, what I see happening is if you're in that situation where you don't know the comp, the listing broker is not offering, you want to get that offer in, but you don't want the offer to just be accepted and then the compensation that was never resolved, you submit it with this offer, and hopefully the listing agent, when they get the offer, they call back, they say what compensation the seller is willing to offer, and you get it worked out in advance before the transaction needs to be executed. Then you never need the GG. But if you're in that situation where you want to get the offer presented, you don't know what it is, stick this in there. That way the buyer is covered and they know that the offer is contingent on getting the compensation worked out. So if we want to go back to FF, FF is going to be a situation where the buyer knows how much the specific number they want the seller to pay. And then you can put the number in and just ask for it up front as a credit from seller to buyer. GG is when you don't know what those numbers are, but you know you need to get the compensation worked out. Then you're going to put it, make the whole offer contingent on getting the compensation worked out for the benefit of the buyer.
Or potentially you maybe know what those numbers are verbally. Maybe you've received, the listing agent has provided a verbal confirmation as to the amount, but they haven't documented it. Maybe the broker's out of town. Maybe there's just a reason that the CASB or the CABB have not yet been executed or provided to the buyer's agent. So you want to make sure, again, that gives you the opportunity for the compensation to be worked out as part of the contract execution process. So we're going to flip back to FF and go through just the rest of those terms. So we go through the either percentage of the purchase price or a flat dollar amount or percentage of the purchase price plus a dollar amount. And as we talked about, the settlement does not allow a buyer's broker to receive any more compensation than it appears in the buyer broker agreement. So nothing in this rider FF is going to amend a buyer broker agreement. If a buyer broker agreement needs to be amended up or down, there are modifications to those agreements to be able to do that. So in the event the credit, though, described in those checkboxes exceeds the amount allowed by the buyer's lender for those contributions, then to the extent permitted by the buyer's lender, you get to check a box. Here's where the buyer gets to submit their offer with an option. Either option one, the balance of that credit, again, above whatever the lender's allowing to be provided from seller directly to buyer, the balance of the credit will be paid by seller directly to buyer broker, that's option one, or option two, the credit in the checkboxes will be reduced to the maximum amount allowed by the buyer's lender. Okay, so again, this is a negotiable term here, but hopefully you're having a conversation with the buyer's lender before they go under contract, before they submit this offer, and making sure that this language is acceptable. But you've got a checkbox. If no box is checked here, then the balance of the credit is going to be paid by the seller directly to the buyer's broker, rather than the credit being reduced. So we've got that default provision in case you forget to check a box. Now, if the credit described above exceeds the exceeds the limit allowed by the buyer broker agreement, then the credit is going to be adjusted to the amount allowed under the buyer broker agreement as may be amended. So if for some reason the buyer submits an offer and the amount of the credit requested exceeds the amount in the buyer broker agreement and the buyer doesn't agree to amend the buyer broker agreement to a higher amount, then the credit listed here is going to be reduced, again, adjusted to the amount under the buyer broker agreement, again, to comply with that lawsuit practice changes. All right, so I think I said this sort of in passing, but this rider doesn't change anything about the buyer broker agreement, doesn't change anything about any other comp agreements that exist. It's just a credit from seller to buyer or credit request. And then we have this broker commissions are not set by law and fully negotiable. You'll see that big bold language, which is a practice change requirement from the lawsuit. That is in almost every document that deals with buyer broker compensation. Now, if I have the buyer and I'm submitting an offer and I add this addendum and I have a specific amount that I'm going to request from the seller, and I have an idea that maybe the listing broker is offering compensation to a buyer's broker, but they're not being clear about it. They're not providing this information. And I want to go ahead and make sure I get my offer in. What could potentially happen is the buyer submits the offer, attaches this addendum, incorporates it into the contract, and the listing agent has to present it to the seller and says, hey, look, the buyer's requesting this credit, for buyer broker compensation. And then the seller is going to say, well, wait a minute. I have a listing agreement with you. In the listing agreement, I've already agreed to pay your brokerage X amount of money. And in the listing agreement, I said, hey, listing broker, you're going to pay the buyer's broker Y amount of money. Why are they including this addendum? And then at that point, a listing broker who's maybe not being completely transparent with respect to the amount of compensation that has been agreed to in the listing agreement is going to have to face their seller and say, you know what, you're right. I didn't provide them with the CABB or the CASB, depending on the terms of the listing agreement. We don't actually need this credit related to buyer broker compensation because I'm going to go ahead and provide the buyer's agent with the CABB, the compensation agreement listing broker to buyer broker, or the compensation agreement seller to buyer broker that has already been agreed upon and referenced in that parenthetical in the listing agreement, paragraph 10A or 10B. So it's very possible that this is submitted with the offer, right, Kristen, but that it might not become fully executed because the compensation may have already been addressed in another form. It just hadn't made its way from the listing broker, from the seller over to the buyer's broker, so that the buyer would know that they don't need to offset that compensation. But
yeah,
yeah, go ahead. Go ahead.
No, I was just going to say, I've heard through the grapevine that there's some agents that think you should just attach CABB or CASB. We caution you not to do that because brokers are not parties to purchase contracts. So that doesn't make sense. There's going to be questions of enforceability issues. There's going to be questions of whether the broker is parties to the contract. They should compensation agreements between brokers and where brokers are a party and writers to the purchase contract between buyers and sellers should be two separate things. So these writers are there to use, but don't.
Just to clarify. Sorry to clarify. I was not suggesting that the counter coming from the seller should attach that comp agreement between the brokers, right? So that broker comp agreement is a separate form that needs to get over to the buyer's agent, so the buyer's agent knows how broker compensation is going to be offset pursuant to the terms of the listing agreement. But do not attach, I'll say it, do not attach the CABB or CASB to the sales contract because those are agreements that are separate and apart. Just like you wouldn't attach a listing agreement to a sales contract, don't attach a CABB or CASB because that doesn't belong in the contract between the seller and the buyer. But this credit addendum does allow you to, again, request the credit, and then the seller could reply and authorize the credit, or counter and say, I'm sorry, I didn't provide the CABB to you. Buyer's broker, here's the CABB. I'm going to counter your offer, remove this credit related to buyer broker compensation because we've already addressed the buyer broker compensation elsewhere. And then, the seller would counter, removing that addendum, buyer would initial and date to accept that counter offer. All right, back to the landed GG. Again, Kristen mentioned this is the scenario where the buyer wants to make their offer contingent for a period of time. So you're determining the number of days. Default time period is 3 days after the effective date. So contracts are contingent upon, and you're checking the box whether a seller's broker and buyer's broker or a seller directly with a buyer's broker executing an agreement with terms acceptable to the buyer within X number of days. Again, nothing here is referencing the opportunity to attach the CABB or CASB to the sales contract. This is just allowing the buyer a period of time to get the brokers to get their comp agreement together. And if the comp agreement is not executed and delivered within the time period, then the buyer can terminate the contract. And if the buyer doesn't terminate the contract, then the contingency essentially doesn't have any further force or effect. Similarly, I think if a buyer submits an offer with this contingency and there's already a CABB executed by the listing broker, they're just going to go ahead and give it to the buyer's broker. And assuming the terms are acceptable to the buyer, then the contingency has been met, right? And the buyer's not going to terminate if the terms are acceptable and they know that the compensation that has been agreed to in the buyer broker agreement is being offset by a third party, whether that's the listing broker or the seller directly. All right, we're going to move on to, was there any, if you have any questions,
I think we had a question from Phil. Yeah, there was a, Phil.
Yeah, go for it.
I don't know if we answered it as we
Sure.
went.
Yes, thank you. Sorry, I didn't mean to interrupt. So I get the right of FF, but could you just include, and what I've been doing in contracts, and maybe I'm not doing this correctly, could you just include in the other section or terms in the contract, the main contract, where you say seller will compensate buyer's agent at X%. And if I have a buyer's agent agreement where the seller is only compensating part of it, but the buyer's agreed to compensate at a higher number, and then buyer agrees to compensate the buyer's agent at X%, so it meets the total of the buyer agent agreement. Is that an option?
So the purchase contract is, you're not a party to it. The broker's not a party to it. You don't sign it, so you can't enforce it. So you can put it there, but if they don't honor it, there's going to be a question of whether you can go enforce that agreement. And there's some case law that says brokers are not third-party beneficiaries of the purchase contract. So that leaves you without an option, an enforceability option, which is why you always need your separate comp agreements. You always need, and in theory, you're going to have a buyer broker agreement that agrees to the amount that you're supposed to be paid. But if you did something where you only told, the buyer agreed to one amount, but you cap their out-of-pocket expenses, which I've seen a lot of people doing, something like that, then you might be, if you can't enforce that purchase contract, you might be stuck taking that lower amount on your buyer broker agreement because that's the only contract that you're a party to and that you have the ability to enforce.
Okay, so if I didn't use right of FF, because that sounds like it's shifting the credit back to the buyer, right? I could use one of the other documents, would be either listing agent or broker to broker agreement, or seller to broker, buyer and broker compensation. That's the separate agreement where they've agreed to whatever they're going to compensate. Okay,
and that should be a separate contract.
It is, yes.
Yeah, the purpose of GG is just to make sure it's contingent on getting those contracts signed, but they still remain separate and away from the purchase contract. But Rider FF, if you've got the full amount that the buyer has agreed to pay, I mean, it does get a little squirrely in your scenario because the buyer only agreed to pay a certain amount. They said you could receive X amount from seller, and then they would pay a certain amount. So that does make the credit not work great in that scenario.
Mm-hmm.
But if the buyer was in theory on the hook for the total amount, then you could just credit the total. And when it gets to the closing table, you submit your buyer broker, that becomes an expense of the buyer. So on the buyer line, it says buyer pays the commission, and then there's a credit line for the same amount, and then it works out.
Correct. But Kristen, I still think it works as well, even if the seller is only agreeing to pay a portion of the buyer broker compensation. You just submit the offer with a portion of whatever percentage of the purchase price or dollar amount that you're requesting from the seller. Buyer already knows that they're on the hook to pay their buyer broker X%, and they're only asking from seller, listen, based on this purchase price, I'm okay coming out of pocket for some of the compensation to my broker, but I would like a credit from the seller at closing for a certain dollar amount. Still, in your scenario, Kristen, you're going to have the buyer broker agreement knowing the amount of the buyer broker compensation that the buyer broker is due. So it's purchase price plus buyer broker compensation amount, and then credit from seller to buyer to whatever credit amount the seller has agreed to pay directly, again, pursuant to FF. Similarly, though, if you have a compensation agreement, listing broker to buyer broker, or a CASB, seller directly to buyer broker, and let's say the amount that the seller's broker has agreed to pay, or the seller has agreed to pay, is not the full amount of that buyer broker compensation. You're still purchase price plus buyer broker compensation amount, but the portion that's being agreed to be paid by the listing broker or by the seller is offsetting that amount that's being paid for by the buyer. I've heard brokers in that scenario will say, listen, I know that if the listing broker is not going to pay all of the buyer broker compensation, my buyer may be in a position where they cannot come, with cash to closing. So I may be in a position of amending my buyer broker agreement for this specific transaction, for this specific property, modifying the buyer broker compensation that I'm expecting. And the reason I'm saying for this specific property, for this specific transaction, is because once you modify your buyer broker agreement, if you don't specify that it's just for this particular transaction, and let's say this deal falls through for whatever reason, you have an amended buyer broker agreement that has now said that you are agreeing to accept less compensation. And maybe that wasn't your intention for the duration of your buyer broker agreement to accept less compensation, right? So make sure that if you're doing a modification, modify it specific to this particular transaction. Anything else on BBAs, comp agreements, timing? Again, similarly with rider GG, make sure you're checking the box in other when you're going to attach it. And again, if you have, let's say that you're going to submit the offer on a Sunday afternoon and the listing broker's already provided the CABB to you, you don't need to attach rider GG. You already know that listing broker is going to be paying buyer broker compensation or offsetting buyer broker compensation in a manner that is acceptable to the buyer. So if you've got the CABB, you show the buyer the CABB and say, listen, this is the contract that replaced that offer of compensation that was on MLS. Right, the listing broker direct to buyer broker, that offer of compensation that's no longer on MLS is now documented in a CABB compensation agreement, broker to broker. Buyer, don't worry about it. We've got this amount in our buyer broker agreement, but look, it's being completely offset by the listing broker's offer of compensation to me as buyer broker. If you have the CABB or the CASB and it's acceptable to the buyer, then again, you do not need to attach GG. This is just in this scenario where you don't have those agreements executed or maybe not executed at an amount that's acceptable to the buyer and you would like to make it contingent upon those agreements. Kristen knows how I feel about this. My hope is in the future we don't need a rider GG because if the agreements are regarding compensation are worked out before the buyer is placing an offer. But I know in the real world, not in my attorney perfect world, but in the real world, things aren't always in that kind of a neat order. So hence the option to use rider GG or FS. All right, we ready to go into condos?
Yes.
Yeah. Okay.
Unless people have, anybody else has questions. I know there's, it's a lot of paperwork. The new way is a lot of paperwork. So.
It is. So I will say that I did not attach the entirety of the new FARBAR Rider A condo rider. It was revised September 2024. I just want to highlight a couple of things. Look at the very bottom in yellow. It's CR-6XX. That is the most up-to-date version of the condo rider. The previous rider version came out in 2023. Make sure you're using 2024. And I'm going to say something very bold. Also, go back to your current listings right now. Take the information from the current condo rider 2023 form that you have, put it in 2024 version of the condo rider because this language that's in paragraph 5 is statutorily required language that is a buyer is entitled to receive. If the buyer does not receive this language, again, as of October 1st, the buyer doesn't receive this new language, the buyer can terminate the contract and we don't want that to happen. So all of your condo listings right now, if you have a condo listing, you've got a condo rider, you've probably uploaded it into MLS, you're doing a great job making sure that information is available to the buyer's agent. Now you know there's a new condo rider with 2 new required disclosures in it. You're going to take the information from the old rider from 2023, move it to the new rider 2024, make sure the information is still accurate, the fees are still accurate, the property management company, that kind of stuff is still accurate, and then have your seller sign it. And then put it back in the MLS, make sure that information is available for your buyers. Again, this is a new form. And you're going to say, well, Erin, I already have a condo rider. It was executed 3 months ago and I took the listing. I'm going to say, great, but the law changed. Make sure you're updating this form to use the 2024 version of the condo rider. Okay, if you haven't done that yet, make sure you go back and do it. And we'll talk about now the differences. So, subtle, but important. So if you look at the big bold language, the blue highlighted language, instead of just having the most recent year-end financial statements, the statute changed to say a copy of the most recent annual financial statement and annual budget, prospective. I know good buyers agents were asking for that budget anyway, so the buyers could know sort of what's coming down the pipeline, what the funds situation are, especially as it's very difficult these days to sell a condo. But now it is required by law. So buyer is entitled to receive not only the declaration, the articles and the bylaws, and any amendment thereto. Those documents, those three that I just mentioned, are recorded in the public records, but also the rules of the association, so the rules and regulations, the most recent annual financial statements, the annual budget, and the frequently asked questions and answers document. So unless, I'm surprised to see sometimes in paragraph 5A that's checked, and it's checked and a buyer knows that they haven't received the document. Don't check the box if you haven't received the document. Chances are the buyer actually hasn't received those documents. And if you've got paragraph 5A, I would also suggest if you're the listing agent, don't pre-check that. Seller, don't pre-check that because you don't know if the buyer's actually received those documents. So paragraph 5B is the more likely scenario that you're going to be, and it includes in the voidability rights the normal 6 pieces of information. Now I have to start saying 7 pieces of information because it now includes the annual budget. So for those same condo listings where you've got the condo rider A already executed in the 2023 form, and you probably have all 6 pieces of information saved, uploaded in MLS, and a note to the buyer's broker to say, hey, all the documents are here in MLS for you to take. Go back to all of those listings, request a budget, upload it with the rest of those documents, and make sure that those documents are being received by the buyer. Sometimes these folks will say, well, how do I know if the buyer received the documents? Kristen, how do you ever know if the buyer has received those documents? Is it enough for me to say as a listing agent, the documents are known MLS, so the buyer's broker must have taken them and given them to the buyer? I trust that that has happened.
So ideally you would have a receipt or an acknowledgement.
Yes.
Yes. I don't know if you screenshotted the next part.
I did. Well,
okay. Yeah.
Yes. So Kristen, do you want to talk about the sort of the genesis of this disclosure and what it means for our buyers? This is language that pulled directly from the statute. So if you're looking at paragraph 11 on the screen, it's 718-407. It is a new part of the condo law. And here's the disclosure summary. And again, when you see this all caps language and a reference to a statute, chances are that language came directly from the statute. So this is statutorily required disclosure summaries that are required to be provided to a purchaser. So especially if you have a buyer who's purchasing one of these types of properties, you want to make sure that they're receiving the new condo rider, again, revised in 2024. All right, what is this about?
Yeah, and sorry, actually, I thought we had the receipt language there, but we don't. But that's okay. Whether you're using Florida Realtors condo receipt, which I believe was updated yesterday. It hit my inbox. I have not reviewed it yet, but I do believe it came out. The updated receipt from Florida Realtors. While I go through this next piece, maybe Erin, you could see if they posted it.
Yeah.
But
sure.
You can use those receipts to make sure that you have confirmation that the buyer received the documents. Now it's updated to show all the new documents and that the rescission period has concluded. That rescission period is a statutory rescission right, so you can't waive it. It's out there, and so you got to get those receipts. This new disclosure you're going to see at the end of the document, I'm sure people are going to ask about it, or maybe they'll just float over it. This arises from mixed-use condos and condos that are like hotel operated. That's kind of the genesis of it. It could have further implications in that, the way it's written, but think of this as applicable to Four Seasons types of places that are part hotel, part condo, and the common elements are managed by the hotel operator. In those types of real estate transactions, there were issues in that the hotel operator would have complete control over the condo elements, but the the condo owners in that hotel mixed use development would still have to pay for the management of the common elements, and they would have to pay, but they wouldn't have control over the budgets. So there became issues with the hotel owners versus the condo owners in those types of building. And now, from a consumer protection standpoint, the legislature has passed this disclosure that has to be given for condos that are in this type of mixed use area. What this disclosure says to this prospective buyer is the common elements may not be controlled, the budget may not be controlled by the owners of the unit. This may be subject to some sort of agreement with the hotel operator or whoever the case may be. So if you deal with any of those sales in those Four Seasons, or I'm trying to think some of the other ones that I've seen. Four Seasons is a one.
Like a Ritz-Carlton resort. Yeah. Like a Ritz-Carlton or Marriott. Mm-hmm.
Yep. If you have ever done one of those condo sales, then you want to make sure that you point the buyers to this disclosure. This disclosure, if you're buying new, you might have a better understanding of everything that happens, but in resale, you might be buying into one of these condos, not understanding perfectly that you don't have control maybe over those common elements. So that's where it comes from. I know it's a little complicated.
I'm coming.
Oh,
I'm bringing it
Kimberly
over.
Kimberly. Okay, I'm going to share it real quick. Is this the new one that came out yesterday? Here, I'm going to share.
Yep, so this has a revision date of October 2024.
Yep, October 2024. Okay, so we've got the added documents in here. So also, however you get your documents, whether it's Form Simplicity or you use a third party like App Files or whatever the case may be, make sure you're getting all your up-to-date documents. There's so many new forms that some of those third-party providers have been really behind. So just make sure if for any reason they haven't uploaded the new forms, you can always go to the Florida Realtors website, or you can go to Form Simplicity and pull those down. That way you're working with the latest documents. All right, so here it is. Thank you for sharing, but yes, it's at the bottom, revised 10/2024.
Yes. Also, if there is, I'm looking at the bottom of the screen, if there is a milestone inspection or a structural integrity reserve study, gives the buyer the opportunity to confirm that they have received the inspector prepared summary of the milestone inspection report and the structural integrity reserve study if it exists. So again, it has multi-function, but condo docs, buyers also acknowledging receipt of the condo governance form. Oh my goodness, you guys, the condo governance form was updated in 2021. So if you have an old condo governance form, that's a DBPR form that is not specific to a particular condo, but a buyer by statute is entitled to receive it. The old form was 2011, new form is dated 2021, updated. So make sure, again, whatever your buyer has received, that they're checking the box, but also make sure you're not pre-checking the box for your buyer. If they haven't actually received the document, don't have them confirm that they have received it. That sounds like a very silly thing, but make sure that if your buyer's trusting you to say, oh yes, I've received all the documents, make sure you go through all of the documents and they've actually received what they're saying they have received. The statute, the law actually requires actual receipt by the buyer, not by the buyer's agent. So make sure that, and if you're having trouble getting a copy of that receipt, because the receipt's not required by law, right? The receipt form to be executed by the buyer is not required by law. The buyer is just entitled to receive those documents. And I do hear sometimes folks ask, well, who's supposed to get this? Who's supposed to get this condo rider, or, these documents, the declaration and all that kind of thing. And the statute says the agreement's voidable by buyer by delivering written notice after execution of the contract and receipt of these documents. To me, if you're a transaction broker in the state of Florida, it doesn't matter who gets them. The seller is in the best suitable position to obtain the documents to be able to provide to the buyer. But if I'm the buyer's agent, I know this information is very important for a buyer to receive. I want to make sure that they receive it. So if you've got a listing agent, it's their first listing, they don't know yet to get all this information from the association, ask them for it. Don't shame them, but ask them for the information and say, listen, It's important for a buyer to receive this information, and also the buyer has avoidability rights. Let's go ahead and make sure that the buyer receives the information in a timely manner. And if the buyer or the listing agent doesn't know where to get the information, you are an experienced agent, talk them through this because you were a new agent at one time too. So make sure you're requesting the information, and then make sure that the listing agent or the seller are providing it to the buyer. Now, Kristen, do you foresee any other changes to this condo rider before next year?
Oh, are you talking? Yes. Hold on. Not the receipt, the rider. Yes. The farmer committee is working on more edits to the rider. We're just not there yet. And those come out of some issues we've heard of with the way assessments are noted, and it can be a little bit confusing as to if assessment was noted, for example, in the minutes or some sort of big project change, and there's an argument that sellers knew about it and sellers didn't know about it. So we're trying to figure out how to best address that. But yes, you can anticipate more changes in the future.
Yep. And also we know that all of the condos that are subject to the milestone and SERS reports are supposed to have their information completed by, or their studies completed by the end of this year. And the statute, the law actually already provides in the statute that all contracts executed after December 31st, 2024 need to have additional disclosure information. Question one is like whether this property is required to have a milestone in SERS, yes or no. Whether, and if yes, it's required to have it, whether SERS was completed. And if it was completed, then the buyer has an avoidability right that is already baked into the statute. It hasn't yet made it into the condo rider because it's not effective until December 31st, 2024. So again, we will come back to you towards the end of December, or in December, as soon as the form is available, to make sure that all of your condo riders that have gone from the 2023 form to the 2024 form are subsequently updated to make sure you're providing the appropriate statutory disclosures with respect to milestone and SERS that give avoidability rights to purchasers in the event those milestone studies, structural integrity reserve studies are required, but and the documents haven't been provided to a purchaser. So again, I wouldn't, I hear some folks getting very frustrated that the information is not available. Make the request of the association or the property management company, and if the answer is no, we don't have them yet, that's good information for a buyer to know, especially if there's going to be a special assessment coming down the pipeline, to be able to pay for the studies, okay? So not just to pay for the repairs, to deal with some of the structural issues, but also to pay for the studies themselves. So be on the lookout for further changes, not just because we want to make the condo rider better for the consumers, easier for the consumers, but also because the statutes require it by the end of the year. So, all right, speaking of statutory changes, we also have a flood disclosure. So this is a Florida Realtors form, not a FAR bar form. So I might clarify the difference a little bit. So Florida Realtors, the FAR bar Joint Realtor Attorney Committee prepares the FAR bar contract, the as-is contract and the standard contract, and all of the addenda, CR comprehensive rider, all of the addenda that are attached to the contract. This isn't a disclosure, so it's not an addendum. This disclosure is required to be provided for all residential real estate from a seller to a buyer. The seller is required now by law under Chapter 689-302 to provide a flood disclosure to a purchaser at or before the time the sales contract is executed. So for all residential properties, seller has to provide this flood disclosure. So if you have a listing right now, whether it's a condo, I'm going to say whether a single family home, vacant land, make sure you're updating your listing. Get this flood disclosure executed by the seller. So there's
probably tomorrow.
Tomorrow at noon. Hey, John Casey, I'm going to mute you. Okay. So thank you. So seller has to provide the buyer with a disclosure at or before the time the sales contract is executed. You have the property address here, and there are just two very simple questions of the seller related to what the seller has done with respect to the property. Also, there's a disclaimer at the very top regarding flood insurance, of the disclosure section. And again, this language came directly from the statute, and it says homeowners insurance policies do not include coverage for damage resulting from floods. That's one. Buyers encouraged to discuss the need for separate flood insurance coverage with the buyer's insurance agent. So it's a disclosure to the purchaser. And also, paragraph 1, seller saying seller has or has not filed a claim with an insurance provider related to flood damage on the property, including but not limited to a claim with the National Flood Insurance Program. So one, a seller has or has not filed a claim related to flood damage. Number two, seller has or has not received federal assistance for flood damage to the property, including but not limited to assistance from FEMA. So if the seller has or has not, seller would know if they have or have not filed a claim for insurance to an insurance provider or received assistance from FEMA. Make sure you're updating all of your current listings because the seller is required to provide this disclosure to the purchaser prior to or at the time the sales contract is executed. And then we've got some more explanations of what they're determining to be flooding. When we think of flooding, we're thinking water from the outside in, not from I left my faucet on and flooded the inside of my home, but rather water is coming from the outside of the home into the home.
Yeah. If I can just make a quick note, I've had a few folks ask me if this could be executed at the stage of the listing stage. So, and that makes sense. I know, so as best practices, sometimes we try to get that seller's disclosure up front, which I think makes sense. But remember, if you do the flood disclosure or the seller's disclosure, or anything like any type of disclosure at the time of listing, that's great. But the obligation to disclose is as a purchase contract. And we just happen to live somewhere where things can change on the daily, i.e. today, between today and Friday.
Yeah.
A house that maybe was not flooded has flooded as of Friday. So you can do those documents, but you always have to double check at the time of purchase if anything has changed. So I don't know that it's great, especially for the flood one, to do that up front. I would say probably do it at the time of the purchase contract being executed, so you just don't accidentally give one document over and something has changed. You know, if you had asked me this 3 years ago, my opinion might have been different, but nowadays it feels like the weather makes this, you know, these things change quite quickly. So just know that the obligation
so then maybe
purchase contract goes out, not your listing agreement phase.
Okay, so then maybe as a reminder, have this form with the seller name and the property address uploaded into your system, ready to go to the seller prior to contract execution. That way you don't forget it. So it's part of your forms checklist, part of your becomes part of your process that you know that you have to give it to the buyer prior to contract execution. Just don't forget it. You know, this is a sort of a trick question for all of you. What happens if it's not provided?
I'll answer. The statute doesn't
Kristen,
say.
What happens?
The statute
doesn't say.
And this is not the first time the Florida legislature has put a disclosure requirement out into the world without saying what the ramifications are if you don't comply. We know from the condo statute, if you don't provide condo docs, the statute gives you a right to rescind the contract. So like when that we know what the remedy is for not doing that. For this, we don't know. There's been other types of statutes that have come out. There's been some local ordinances that have come out of Miami-Dade and Broward and things like that that have put out these, you must disclose, but there's no obligation, there's no clarity as to what happens if you don't. So my recommendation is to disclose because the statute allows. Whether it gives the right to terminate the contract, I don't know. But I will say, if there is a closing and something was not disclosed properly, and there's a statute that says it was supposed to be disclosed, it's going to kick it into the area of case law on seller's disclosure issues, which requires disclosure of known defects and things like that. So I do think you could be putting liability on the seller if they don't disclose something that's required by statute. That's
absolutely.
You have a different opinion, but that's my opinion of it at the moment.
Absolutely. I mean, I would say that, you know, whether the property has flooded and someone has received insurance funds to deal with the flood damage is a factor, condition that materially affects the value of the property that should be disclosed. So again, I think it's a good thing. Perhaps we'll see maybe a glitch bill with the legislature to update this to give the and what if it's not provided. But we don't have to worry about that because we're all going to make sure that we provide it prior to or at the time of contract execution. Our next class will be on Tuesday, November 11th. And I cannot believe we're saying this, Kristen, but it has been 1 year since you dressed up as Princess Peach on Halloween, and we had the jury decision on the Citra Burnett case that had the $1.78 billion judgment. And we've had a lot happen in this past year. So we're going to talk about where we are today. Note that Tuesday, November 12th is almost 2 weeks before the final judge approval that we're anticipating on the proposed practice changes and the proposed settlement for the NAR lawsuit and Citra v. Burnett. But we're going to talk about where we come from, like where we are now. Maybe we'll have a couple of months worth of actual in the field practice to see how these forms are working out. We can talk about any challenges that we're seeing with those forms. And yeah, so we'll see you Tuesday, November 12th from 10 to 11. And Kristen, if you want to stop the recording, then we can have folks, if they want to ask questions, maybe not on record, we can stick around for a couple minutes to answer those.
Okay.